tint is illegal. So I want to test it and let you know for sure.
Oh, well, I'm not letting you test it, so you can write it.
Everyone's off the airport route.
You can write it.
Okay. So you're not going to let me test your tint?
No, sir. You can go ahead and write the ticket.
Ma'am, I will give you 30 seconds to make her either get arrested or make a decision.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. The video today comes to us from the good folks over at the YouTube channel Honor Your Oath Civil Rights Investigations, which is a channel that I've followed for a long time. It does really good work in this space. Now, I've had a bunch of people ask for me to comment on this case from a lawyer's perspective, so I'm going to do that with the caveat that I probably do not see this case the way the courts would see it, but I'll explain both sides of it. Now, I have done some substantial edits to the video just to highlight the sort of important points for the purposes of our discussion, but I suggest you go over to Honor Your Oath's channel, watch the video for yourself in its entirety, and give them credit for sharing it. Let's take a look at the video and we'll come back and talk about the law.
Hey, how y'all doing?
Yeah.
Officer Code TPD, do you have your driver's license?
What happened?
Well,
Yeah.
your
What did
tint
happen?
is illegal. So I want to test it and let you know for sure.
Oh, well, I'm not letting you test it, so you can write it.
Everyone's off the airport route.
You can write it.
Okay. So you're not going to let me test your tint?
No, sir. You can go ahead and write the ticket.
You don't have your driver's license with you?
I'm not sure. Hey, man, I got to get rid of this car. It's the car. It's always a problem. They always think I'm a male. I'm not.
All right.
Here we go, actually.
A male. I'm going to have to test your tint. I mean, I'd rather do that than have to take it further than that. So if you just roll it up a
Okay, yes,
little.
sir. Let me call my daddy.
Once everyone gets overhead, we'll go through this breaking up time.
Okay. What are you calling him for?
Property.
You can write the ticket.
So we can,
No, I have to test it to know where it's at.
Daddy, I done got pulled over. And here's all the way black. Daddy, I just got pulled over. This officer literally waited. He literally went in a neighborhood to pull, like he went in a
There's
neighborhood
nothing
waiting for me to
against I
pull
can't
out
do
so
that.
he could jump
That's
behind
fine.
me.
Please.
Now he's talking about my team, but I told him I don't want him to test my team. Just right.
Sir, if she doesn't let me test it, she'll go to jail. This is ridiculous. I'm just...
He said if I don't let him test my tint, then I'm going to jail.
Yeah.
But this man is literally targeting me. He literally purposely drove through a neighborhood. That's what I thought. I know you can't go to jail for.
Right now, she's resisting this investigation. So if she can't roll the window up...
You can't.
Sir,
What?
You don't have to cooperate.
Daddy, can
Excuse
you
me?
please come here?
Okay, you have
Where
to...
you at?
You have to
I'm at
cooperate.
the same store where I just got a put in me at. This man got me at the same spot where I just got to go.
I'm really not trying to do this today.
Yes, sir.
Ask him is that an order?
Yes, it's an order. It's a lawful order for you to roll your window up a little bit so I can test it. I'm not trying to do
But
this
what if she
today.
don't want to let you test it?
Then
She
she'll
can't take her to jail,
then
man.
she'll be resisting the whole investigation.
Not resisting. That's not resisting.
Yes, it is. Yes, it is, because you're not allowing me to do my job.
Okay, listen, she don't have to help you do your job.
Yes, she does.
She don't have to help you investigate. Okay, take her to jail and I'm
not
gonna just
a
do y'all.
lawsuit.
Do your job then.
It's not a
Do
lawsuit.
your job and we're gonna see.
Can I talk to you and not him, please?
He said he want to talk to me and not you, but I don't feel the need to talk to him because
It don't matter. You don't have to let
You
her
waited for me to pull out of that
That
neighborhood
doesn't
to get
matter.
behind
None
me,
of that
sir.
matters.
You literally did that.
Ma'am, roll your window up a little bit. I'm going to test it, and I'll let you know where
You
it's at.
don't have to cooperate.
Can you just write me the ticket, sir, and we could do it like that?
I need to know where it's at and write your ticket.
You can't write you a ticket if you can't test.
Exactly. So now you're
That's
making
why
my
he
job
wants you to let you
impossible.
test.
That's the definition of resisting. So if you can just roll it up a little bit, I'll test it and let you know.
Resist.
If it's illegal, it's illegal. If it's good, I'm going to let you go. If it's illegal, I was thinking about just giving you a warning. You're making it really difficult, man.
Call the sergeant. Tell him call the sergeant. Tell him call the sergeant. I'm heading over there. Tell him call the sergeant.
Okay.
Right there to on
Oh,
I'm heading over there. Tell him-
Resisting. You're not complying.
And they know the windows.
You to do that. I'm just saying.
I stopped this vehicle.
Sir.
This is Home Depot's worst nightmare. A new gadget is flying off the shelves, but Home Depot is...
So we'll walk in there together.
Done?
So I stopped this vehicle for tint violation.
Okay.
You want to use my...
Any unit working a special event at Southwood Rec Center to Southeast. Any unit working special event at Southwood Rec Center to
She
Southeast.
wants to speak with Sergeant. I defer to that. I want you to talk to her, you know, explain the situation, but
Okay, ma'am. I see you're a correctional officer. If you get arrested, I'm pretty sure you won't be anymore. So here's the thing. For window tint, you have to roll the window up. It's a lawful command. If you fail to obey a lawful command, you'll be arrested.
Can you be an officer, then I need to pull my window up.
Well, no, as a citizen, you need to do that. I'm just saying you have a significantly more powerful consequence of getting arrested. I understand. Most people don't. Ma'am, I will give you 30 seconds to make her to either get arrested or make a decision.
Tina, who are you talking?
25 seconds. 20 seconds.
Roll your window up and let him do that job. Listen, for resistance.
15 seconds.
It's not the point.
Don't do all. Listen, don't ruin your career over.
10 seconds.
Tina, really? Please don't do that. Roll your window up and let him test it. Listen,
5 seconds.
Okay, go get it. Go get it.
Go get what?
Go get it.
He has it right here. Roll your window up.
You have to roll the window up, man.
Roll your window up.
I got it. You roll it up, I want to test it.
All right.
Roll it up.
Time's up.
I want to test it if you roll it up.
I'm going to roll it up.
Roll it up, Brian. Roll it up.
Okay.
Last chance. Roll it up. Roll it up or go to jail. Take her to jail. All right. We're done with this. You're under arrest. Yes, sir. This is Sergeant Rudd, Tallahassee Police Department. We just arrested one of your correctional officers.
Sergeant Rudd?
Yes, sir. R-U-D-D.
Okay. Y'all pressing charges on her?
Yeah, it's she's getting arrested for resisting without violence.
All right. Is there anything else you wish to share with me?
I'll gladly tell you exactly what happened. She got pulled over for a window tint violation, and she wouldn't roll her window up so we could test it. And after 25 minutes of trying to convince her that just roll the window up so we can test it and you can be on your way with, at worst, a ticket, she refused to comply. At that point, we gave her the option, like, all right, you can either roll the window up and let us test it, or we can arrest you and then roll the window up and test it. And she went with, she didn't want to roll the window up, so we arrested her. And we tested the window, and it wasn't legal tint, but so she's getting a ticket and charged with resisting arrest.
Alrighty, she's having a bad day, ain't she?
She is, and the worst part is she's still wearing her uniform, so I'm assuming she didn't go into work.
So it looks like what we have here is a correctional officer that's been stopped for a suspected window tint violation by a Tallahassee police officer in Tallahassee, Florida. The windows are rolled down all the way when the officer approaches, so it's obvious that one of two things has to happen. Either one, the officer has to get the driver to roll up the window enough to test the tint, or two, the officer has to get the driver out, roll up the window himself, and test the tint. So the issue becomes, is a person required to assist an officer with their investigation? So this poses a couple different questions. Number one, is a person required to assist an officer with their investigation? And number two, do you have a Fifth Amendment right to refuse to do that? Well, like everything else in the law, it depends. It depends on who you ask. It depends on where you are. And I'll give you a spoiler alert. If you're expecting to get a definitive answer from this video, you're probably going to be disappointed. My answer, as a practicing non-Florida attorney, is that a person has absolutely no obligation to assist an officer in their investigation, and I think that's been pretty much established. However, there was a 2017 case in the 11th Circuit Court of Appeals, which is the federal circuit that governs Florida, indicating that the courts would see this differently. So this exact issue, like on point fact for fact, best I can find during my legal research, has not been litigated. However, some of the facts are close enough to being on point that we could get some insight by looking at a couple cases. So the first case we're going to look at is a case called United States versus Holley, which is a case that came out of the Middle District of Florida and was decided by the 11th Circuit Court of Appeals in 2017. The facts in Holley are these. Holley is stopped by two Sanford, Florida police officers for basically two reasons. Number one, failing to stop at a stop sign, and number two, that the window tint's darkness appeared to exceed what was permitted under Florida law. Upon being stopped, Holley exited the vehicle and attempted to flee and was ultimately tased and arrested by the officers. Now, the Sanford police officers went to the car and they opened the door because the tint was so dark they couldn't see inside. So their justification initially for opening the door was to make sure that nobody else was in the vehicle. Once the door was open, the officers saw a gun in plain view. The officers also then rolled down the window to check the window tint against their tint meter. Holley was ultimately charged and convicted, but he filed a motion to suppress, arguing that the officers violated the Fourth Amendment by opening his door, and the trial court, the district court in the Middle District of Florida, denied the motion to suppress. The 11th Circuit agreed to hear the case, and they also said that the court was correct in denying the the motion to suppress, and they used a 1986 United States Supreme Court case called New York versus Class as justification. They said that the officers were justified in opening the door. So now we have to go back and look at Class to see what that was all about. So in the Class case, there was a traffic stop with similar facts to Holley. Class was a motorist who was speeding and had a cracked windshield, and he was stopped by New York police officers, and he voluntarily exited the car to approach one of the officers to talk. The backup officer that was there assisting the primary officer went over to the door of the vehicle that Class just got out of and opened the vehicle door in order to try to find the VIN number. When the officer couldn't find the VIN number, he noticed some papers in the vehicle's dash, and then he moved those papers out of the way in order to reveal the VIN number of the vehicle. And while the door was open, in plain view, the officer noticed the handle of a gun under the seat of the vehicle, and ultimately Class was charged with carrying a weapon. Now, the court said in that case that because of the state's interest in regulating automobiles, it was not a violation of the Fourth Amendment for the officer to open the door to look at the VIN number for the limited purpose of looking at the VIN number. The court further reasoned, and this is the tricky part, that had Class been in the vehicle, the officers would have been justified in asking him to move the papers. But officer safety allowed them to not have to return Class to the vehicle and ask him to do that, because ultimately they ended up finding a gun, and so under the holding in Pennsylvania versus Mims, it would have been justified to get him out of the car anyway for officer safety concerns, and it would have been unreasonable to expect the police to put him back in the vehicle where the gun would have been found and ask him to move the papers around. So the court said basically that the officers were okay to move the papers and look at the VIN number. They also mentioned that New York law has a provision allowing officers to demand to be able to inspect the VIN. And as I mentioned just a couple seconds ago, they even managed to tie this all together and put a nice little officer safety bow on it to justify the actions of the police officer. So the 11th Circuit used the language of the Class case to make the following statement in Holley. On this record, opening the car door to test the window tint did not violate the Fourth Amendment since it satisfied the factors in Class. The safety of the officers was served by the governmental intrusion, the intrusion was minimal, and the search stemmed from some probable cause focusing suspicion on the individual affected by the search. First, opening the car door served two purposes. Now again, we're talking about Holley. It enabled the officers to enforce the window tint regulation, and because Holley had fled the car during the traffic stop, it mitigated the risk to the officers posed by returning Holley to the car. So again, it used the Class language to say, we don't expect the police to return this guy to the car and ask him to roll down the window. The officer is fine to do it himself. Second, the court further reasoned that the intrusion in opening the car door was minimal. As the record reveals, it was necessary to roll down the window in order to test if the window tint was in compliance with Florida law. And then the court makes this statement, which I have an issue with. If he had remained in the car, the officers could have required Holley to roll down the window. Now, I disagree with that. We'll cover it more in the closing. I think that's a misreading of Class, but we'll cover it more in the closing. So there you have it. It's an 11th Circuit opinion where the court is saying that if a driver was in the vehicle, the police could require the driver to roll down the window to test for tint. Now, to me, here's where it gets weird. Both of the cases we've discussed touch on the officer's reasonableness in opening the door and entering the vehicle in order to conduct this activity themselves. Neither of them discusses actually trying to force a person to do it for them or participate in the investigation. And I would argue that that is a very different thing. See, we're not talking about an officer asking the driver out of the vehicle pursuant to the Mims decision and then rolling up the window himself to test the tint. My argument is, and will always be, that if you think you can try to force a person to do something, well then you must be able to argue that you have a right to test the window yourself. And if you have a right to test the window yourself, then you can remove any controversy by not trying to force the person to do it and just doing it yourself. From a common sense perspective, it just doesn't jive for me, unless of course your entire intent is to find a justification to arrest a person who is giving you a hard time, and you realize that the window tint is not a criminal infraction, so you need a criminal infraction to make an arrest. Now, to be clear, I don't get that vibe from the original officer here. I actually think the sergeant was much worse as far as escalating this encounter than the original officer. I think the original officer genuinely just wanted to test the tint, and the sergeant turned it into something it didn't need to be. So the question is clearly not whether the officer can test the tint, but more so whether he can force a person to roll the window up and upon refusal, charge that person with obstructing. Again, my opinion is that he cannot. But again, I qualify that by reminding you that in 2017, the 11th Circuit Court of Appeals made the statement that an officer could require a person to roll the window up. And if the court determined that the order was lawful, there's a good chance of an obstructing conviction under those facts. So first, let's look at the Florida statute on obstructing. Section 843.02, resisting an officer without violence to his or her person. Whoever shall resist, obstruct, or oppose any officer, basically in the performance or execution of any legal duty without offering or doing violence to the person, that shall be guilty of a misdemeanor of the first degree, so it's a misdemeanor and arrestable. So I guess the issue would be how you consider resisting, obstructing, and opposing. Now, opposing, I do think, in this particular language, if the court decided that the order by the officer to roll up the window to be tested was a lawful order, but again, I take real issue with that, and I'll explain in the closing why I think that's a wrong reading of class. But there are a couple different things to consider. First, and I think this cuts against the driver here, remember that the Fifth Amendment allows you to protect yourself against being compelled to be a witness against yourself for the purposes of criminal prosecution. The window tint statute is not criminal. You can't be arrested for violation of it. It's a civil traffic infraction, and for that reason, I think it's possible that a successful argument could be made that compelling a person to roll up a window can't be self-incriminatory, where the penalty for the tint is not criminal in nature. But the flip side of that is, well, what if the person just dumps some sort of contraband, or it's like cocaine or methamphetamine or something, down inside the window jamb, or they're using the inside of the door pocket as a place to hide something? Then you have a situation where you could potentially be rolling something up in your window that could be evidentiary in value and could offer some insight into criminality, and you're being forced to do that. I think a case where those facts are present would probably flip this idea on its head. But it's that kind of facts that it would take to have in play in order for a court to really take a hard look at whether this is actually self-incrimination. Now, my personal opinion is that this is really no different than trying to compel a person to do, say, field sobriety tests or remove their glasses to test their eyes. I see both of those things as protected by the Fifth Amendment, but I also have to acknowledge that the potential penalty for doing field sobriety tests poorly or showing somebody that you have nystagmus in your eyes are criminal in nature. They may lead to a DUI arrest, whereas this is not. But the real, sort of breaking point for whether or not a person has a privilege not to self-incriminate has to do with the thing that they're being compelled to do being testimonial or non-testimonial. For instance, the courts have held that taking somebody's blood pursuant to a warrant, that DNA evidence and blood evidence is not testimonial, because you're not being required to testify to anything or do anything. They're just taking it, and it doesn't have a testimonial value. But I also do have to acknowledge that field sobriety tests, though, are more testimonial in their nature, because you make a person do a field sobriety test, you're making them testify to their condition, in my opinion. Whereas forcing somebody to roll up a window probably would not be considered testimonial, because it only shows the condition of the window. And there could be a justifiable explanation to why that window is tinted that way that has nothing to do with whether or not you committed a crime. The tint could have been put on by the factory or someone prior to that person owning it. So it would be a stretch to say that forcing her to roll up a window would be the same as forcing her to be a witness against herself. Rolling up the window doesn't really say anything about her other than that she knows how to operate the window. Now, again, another question has been raised whether or not the officer opening the door will be a violation of the Fourth Amendment. And remember, the court just told us in Holley that it wasn't a violation of the Fourth Amendment. When we're thinking about the Fourth Amendment, it's all about a person's reasonable expectation of privacy. And the courts have been pretty consistent in holding that when it comes to regulating vehicles, there's a reduced expectation of privacy. And I think the state could make the argument successfully that based on case law, a person would have a hard time arguing that a reasonable expectation of privacy existed in the window glass itself. Because you can't really make the argument that that window glass was providing privacy to the inside of the vehicle in this case because the windows were down. So I'd say in light of the Holley case, at least in my opinion, there'd be no real chance of succeeding on a Fourth Amendment claim because an officer rolled the window up and checked the tint. In closing, and based on the Holley case and the Class case, I think there's a decent chance that this conviction would be upheld in a state court, and I certainly don't agree with that, but we know that the 11th Circuit Court is now of the opinion that the driver can be forced to roll the window up or down for testing. So that kind of places the refusal in the same category of refusing to step out of the car when given an exit order pursuant to MIMS. And courts have upheld obstructing and resisting convictions in those cases thousands of times in nearly every state. The biggest problem I have with the language the court used in the Holley decision in the 11th Circuit is that it actually ignores what the court was really saying in Class. The Holley court used Class as justification because the court in Class said that the officers could have asked Class to move papers to see the VIN. But again, the court said that the officers could have asked, which is different than giving a lawful command. The Holley court converted the word ask to a right to require, and that's not what the Class court said. In fact, the court in Class even said if respondent had stayed in his vehicle and acceded to such a request from the officer, then the officer would not have needed to intrude into the passenger compartment. Well, what does acceded mean? Acceded means to give consent, approval, approval or adherence, to agree, to assent. So in my humble opinion, the 11th Circuit Court misread class, because the class court was discussing the hypothetical situation of the officer asking and receiving consent from the driver. That does not logically convert, at least in my mind, to an officer being able to lawfully command a person to do something. What should have happened here, if it were to remain constitutional, in my opinion, is that the officer should have made his request to ask the girl to roll up the window, and when she refused, he should have given her an exit order pursuant to MIMS. Should have said, okay, step out of the car. And then he should have rolled up the window himself, checked the tint, and issued a ticket and went on his day. So in my opinion, this whole thing was petty and unnecessary. Because again, if you believe you're justified in forcing her to do it, then you should be able to make the argument that once you asked her to do it and she didn't do it, that you'd be justified in asking her out of the car so you could do it yourself. Like the class case, the argument could be made that rolling up the window by the officer was not a search to uncover evidence of a crime. It was for the limited purposes of seeing whether window was compliant with a non-criminal regulation. Had that happened, we wouldn't be sitting here discussing self-incrimination or a violation of the Fifth Amendment or anything like that. We wouldn't be wondering whether she was treated that way because of the color of her skin, or whether it was appropriate for the sergeant to call her boss and try to get her in trouble and all that stuff. None of that stuff would be happening. And in my opinion, it is actually on the sergeant that we had an escalation to begin with here. He should have calmed everyone down when he got to the scene. He should have asked her out of the car, and he should have done exactly what I just suggested. And if they lost the ticket in court under an improper search, so be it. But escalating this encounter while somebody's wearing a uniform, knowing that there's a possibility that they could be armed, the potential for danger to the girl, to the officers, and the passengers, and anybody in the area, was unnecessary. Nor was it necessary to call and report her to her job and get her fired over a window tint violation. That was all ego on the part of the sergeant, in my opinion. He decided that since he had to be bothered to come out, he was going to convert this into an opportunity for this young lady to find out and punishment for asking him to come over there. My prediction is that this conviction gets upheld unless there's like this conscientious prosecutor in Tallahassee that just looks at this and says, no thank you. Because I can promise you that if that case came before me as a prosecutor, I would outright dismiss it. I do think that this is not a case a lawyer would probably take, because I think a civil suit would probably fail on qualified immunity grounds at the summary judgment stage. Because if the lawyer defending the cops is smart, they'd use the court's language in the Holley decision from 2017 as a reason to say at least that even if the officers were wrong, it wasn't well established that this would be a violation of the Fifth Amendment based on the court's language in Holley. And so best case scenario here for the driver are that criminal charges get dismissed and they might file a lawsuit and maybe the city settles out of court so they don't have the publicity attached to it. But if it actually goes to litigation, I think it'll be dismissed at summary judgment. I don't see this turning into like a big settlement or anything. Worst case scenario for the officer, I think, would be like a slap on the wrist for really the sergeant was the reason, and the one that should be disciplined here. The sergeant came out, sort of blazing guns on it, put a time limit, watched the clock. He was being a real smart ass about it. And so I think probably a slap on the wrist to the sergeant for not adhering to a de-escalation policy, and maybe some pressure on the department from the local communities is about as bad as it's going to get for the police in this particular case. Anyway, that's my take on it, guys. I know some of you probably won't agree with it, but you asked me to go over it. I'm giving my honest opinion. This is the way I see it. I appreciate you guys watching it. Please remember to like and subscribe and leave me a comment telling me what you think. Did I get it right? Did I get it wrong? Please watch some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.